They thought I was finished. They stood right there in my kitchen, my son, his wife, and the lawyer they'd hired, laughing quietly about timelines and signatures, about what was already done. I was sitting in my armchair by the window, the one I've had since before my son was born, and I kept my eyes half closed. I let them think I was dozing off. That's what they wanted to see, an old man fading out. I'm 68 years old. I spent 41 years building a cabinet-making business outside of Guelph, Ontario. I built it from nothing, from a rented garage, one truck, and a set of hand tools my father left me when he passed. I built custom cabinetry for homes from Hamilton to Barrie. I poured everything into that business, and when I finally sold it 12 years ago, I took the proceeds and bought 43 acres of land near Elora. Good land. Hardwood forest on the north end, a creek running through the middle, and an old farmhouse I spent 3 years restoring with my own hands. My wife Diane passed 9 years ago. Breast cancer. It was fast, and it wasn't fast. Those two things can both be true at the same time. After she was gone, it was just me and the land, and eventually my son came back into my life with a woman I'd never met and a friendliness I should have questioned. His name is Joel. He's 41 now. When he was young, he wanted nothing to do with the business. That was his right. He went to school in Vancouver, worked in finance, moved around. We weren't close, but we weren't estranged either. We were what a lot of fathers and sons are, cordial, infrequent, a little careful around each other. Then Diane died, and things shifted. He called more often. He drove out to the property with his girlfriend Cassandra. She was charming in the way that makes you work to find the seams. She complimented the farmhouse, asked questions about the acreage, said things like, "This place has incredible bones, and you could do so much with this." I told myself she was just enthusiastic. I wanted to believe that. They got married in the fall of 2019. I helped pay for the wedding. I didn't mind. Joel seemed happy, and I thought maybe Cassandra was simply the kind of person who expressed affection through admiration of things. Some people are like that. The problems started quietly, the way serious problems usually do. Joel began asking about my will. Not directly at first. It came wrapped in concern. "Dad, have you thought about what happens to the property if something happens to you?" And then, a few months later, slightly more direct, "You should really get that sorted. Estate taxes in Ontario are no joke." He wasn't wrong about that, technically. But I noticed the questions always circled back to the same thing. The land, the farmhouse, the 43 acres near Elora. Cassandra started coming out alone once Joel went back to Toronto after visits. She'd linger, help me clean up after dinner, ask about the history of the place, take photographs of the barn and the creek. I thought she was interested in the history. I told myself that too. In the spring of 2022, Joel sat me down and suggested I transfer the property into a family trust. He'd had a lawyer draw up some documents. It was for tax efficiency, he said, to avoid probate, to protect the land. He had an answer for every question I asked, smooth and rehearsed. I told him I'd think about it. I didn't sign anything, but I started paying closer attention. What I noticed over the next few months was methodical. Joel had begun positioning himself as the responsible one, the son who was looking out for his aging father. He mentioned it to relatives. He said it to my neighbor, a man named Roy, who I've known for 30 years. "Dad's getting older. We just want to make sure things are handled properly." Roy told me this over the fence one afternoon with a look on his face that asked, without asking, whether everything was all right. I told him I wasn't sure yet. That winter, I had a health scare. Nothing that turned out to be serious. Chest tightness. A stint in the hospital in Guelph for 2 days while they ran tests and determined it was a stress reaction, not cardiac. But Joel and Cassandra arrived the day I was admitted, and by the time I was discharged, They had spoken to my attending physician, introduced themselves as my primary caregivers, and taken it upon themselves to contact a different estate lawyer than the one I'd used for 30 years. My own lawyer, a woman named Patricia, who had handled my business sale, my wife's estate, everything, later told me that Joel had called her office, suggesting she might have a conflict of interest and that the family would be seeking new representation for my affairs. Patricia called me directly to ask if this was my instruction. It was not. That was the moment I stopped being uncertain. I called Patricia the following week and drove to her office in Guelph. I sat down across from her and I told her everything, the documents Joel had brought, the conversations with relatives, the visit to my physician, the call to her office. She listened without interrupting, and when I was done, she set down her pen and said, "Alec, I think we need to move quickly." My name is Alec Drummond, and from that afternoon in Patricia's office, I started building something they would never see coming. Patricia referred me to a colleague who specialized in elder law and estate litigation, a straightforward man named Mr. Okafor out of a firm in Kitchener. I met with him twice before Christmas. He reviewed everything I brought him and confirmed that while Joel and Cassandra hadn't yet done anything illegal, they were clearly positioning to contest my capacity and my testamentary wishes the moment I passed, or to pressure me into signing documents that would transfer control of the property while I was still alive. Mr. Okafor recommended several things. First, I update my will immediately and clearly, with full documentation of my mental competency at the time of signing. Second, I obtain an independent cognitive assessment, not because there was any question, but to create a legal record that would be difficult to challenge. Third, I establish a formal trust structure of my own choosing, one that protected the land and named beneficiaries that had nothing to do with Joel's plans. I did all three. I also did one more thing that was entirely my own idea. I began keeping a journal, not just a diary. I kept a detailed, dated, factual account of every conversation with Joel and Cassandra that concerned the property, my health, my finances, or my legal affairs. I wrote down what was said, who was present, and what documentation existed. I kept copies of every document Joel had presented to me. I noted the dates Cassandra came to the property alone and what she had asked about. I kept Roy's account of what Joel had said to him. I kept the voicemail where Joel referred to the farm as what we're inheriting. That voicemail. He left it on my phone one evening, clearly not thinking I'd save it. He was talking to Cassandra in the background, and he picked up his phone mid-sentence. The problem is, if he does anything with it before we get the trust sorted, we lose control of what we're inheriting. He realized mid-sentence that he'd called me accidentally and hung up. I saved the recording that same night. Through the winter and into early spring, I was quiet. I went to my appointments in Kitchener. I came home. I split wood. I had Roy over for dinner on Sundays, the way I always had. When Joe called, I was pleasant. When they visited, I made coffee and asked about their lives. I let them believe I was exactly what they wanted me to be. A tired old man moving slowly through his days, easy to manage, easy to steer. Cassandra made a comment once in my kitchen that she thought I seemed more relaxed lately. Joel nodded and said he was glad I was coming around to the idea of planning ahead. I smiled and told him I was thinking about it. I was thinking about it. I was thinking about it. Just not the way he meant. In March, Joel's lawyer sent a formal letter requesting a meeting to discuss my estate planning. The letter was addressed to me, but it was written in a tone that assumed they were already managing my affairs. It referenced the family's concern about my capacity to manage a property of this size and suggested that a formal assessment might be in everyone's interest. They were beginning to lay the groundwork for a capacity challenge. Patricia helped me draft the response. It was polite. It acknowledged the letter. It said I had engaged my own legal counsel and that all future correspondence should be directed to Mr. Okafor's office. Joel called me the same evening. The letter arrived at his lawyer's office. His voice had changed. The warmth was thinner. He asked me who I'd been talking to. I said I'd been talking to my lawyers, the way any property owner would. He said he just wanted what was best for me. I said I knew exactly what was best for me, and I thanked him for his concern. After that, things escalated. Within 2 weeks, Joel had contacted 2 of my cousins, people I rarely see, and told them he was worried about my mental state. He contacted the local municipality with some vague inquiry about land use and the property title that my lawyer had to respond to. He showed up at the farmhouse unannounced on a Thursday afternoon with Cassandra and a man I didn't recognize, who he introduced as a property consultant. I told the consultant I wasn't interested in a consultation and I asked them to leave. Cassandra started to say something about my stubbornness and how they were only trying to help. I looked at her steadily and said that I'd heard her clearly and that if they didn't leave, I would be calling the Wellington County OPP. They left. I called Roy immediately after and asked him to come over. He arrived within 10 minutes and I walked him through everything. Roy is a retired contractor and about as unflappable a person as I've ever known. He sat at my kitchen table, listened to the whole thing, and then said quietly, "Alec, what do you need from me?" I told him exactly what I needed. The court date arrived on a gray Tuesday in April. Joel had filed an application under the Substitute Decisions Act, seeking to have a guardian appointed to manage my property, with himself named as the proposed guardian. The application alleged that I lacked the capacity to manage my financial affairs and that the property was at risk of mismanagement. I drove myself to the Guelph courthouse. I wore a suit I hadn't worn in years, the charcoal one from my daughter-in-law's cousin's wedding, pressed the night before. I had polished my shoes. I wasn't going in looking like what they wanted me to look like. Mr. Okafor met me in the lobby. We reviewed the morning briefly. He was calm. He had a way of standing very still that I found settling. Joel and Cassandra arrived with their lawyer a few minutes later. They were dressed expensively. Cassandra was wearing a coat that probably cost more than my first truck. When they saw me, Joel did a small double take. I think he expected the cardigan, the rumpled posture, the old man who'd been half asleep in his chair. What he got was a man who had been awake for years. They sat at their table. I sat at mine. Their lawyer, a younger man, very confident in the way that comes from not having lost many things yet, arranged his papers with a certain theatrical efficiency. The application began. Their lawyer presented the case, an aging man living alone on a large rural property, documented health incident the previous year, a pattern of making decisions that concerned the family, reluctance to engage in estate planning, refusal of family support. He made it sound reasonable. He was good at that. Then Mr. Okafor stood up. He filed the cognitive assessment first, completed 3 months prior by a certified neuropsychologist at Grand River Hospital in Kitchener, Dr. Amara Mensah, who specialized in geriatric assessment. The report ran to 14 pages. It documented that I had scored in the high normal range on every standardized measure. There was no ambiguity in the language. Dr. Mensah had written that I demonstrated above-average executive function, intact memory, and full appreciation of the nature and consequences of legal decisions. Joel's lawyer tried to suggest the assessment was self-serving. The judge, a measured woman in her mid-50s whose expression had not moved significantly since proceedings began, asked whether the applicant had any competing assessment. They did not. Then Mr. Okafor introduced the trust documentation. 3 months before Joel had filed his application, I had already established a properly structured family trust with Patricia's oversight. The 43 acres, the farmhouse, the outbuildings, all formally held in trust with a designated trustee who was neither Joel nor Cassandra nor anyone connected to them. The trust named specific beneficiaries. It included detailed provisions for what would happen to the land. It was complete, legal, and had been reviewed by 2 independent lawyers. The judge read through the summary. She was quiet for a moment. She asked Joel's lawyer whether his client had been aware of this existing trust structure at the time of filing. He said he had not. She asked Joel directly, because she could, whether he had known that his father had already completed formal estate planning before this application was submitted. Joel said he hadn't known. She looked at him for a moment longer than was comfortable. Then Mr. Okafor introduced the journal. Not all of it. He had selected the most relevant entries and had them formatted as exhibits. The voicemail transcript, Roy's witness statement, signed and notarized, the record of the unannounced visit with the property consultant, Joel's call to Patricia's office, the letter from Joel's lawyer referencing capacity concerns, the relative outreach, the municipal inquiry. Their lawyer objected to the journal entries as self-authored. Mr. Okafor noted that they were corroborated by independent witnesses and communications, and that the voicemail, in particular, was a recorded admission. The judge admitted the evidence. Cassandra leaned over and said something to Joel in a low voice. Whatever she said, Joel's expression didn't improve. The judge asked Joel's lawyer if his client wished to make any statement. There was a brief, quiet conference at their table. Then the lawyer said they wished to withdraw the application. The judge said that was his client's prerogative, but that she intended to address costs. She noted that the application had been filed without evidence of incapacity, that the applicant had been aware his father had independent legal counsel and had proceeded regardless, and that several of the documented actions, particularly the contact with my physician and the call to my existing lawyer's office, warranted serious concern. She ordered full costs awarded against Joel. Then she said something I have thought about many times since. She said that the court's role was to protect individuals from exploitation, including exploitation by family members who may believe their intentions are good. She said that an elderly person's right to manage their own affairs, so long as capacity is intact, is not negotiable. And she said that the documentation before her suggested this application had less to do with concern for the applicant's well-being than with control of his assets. She did not raise her voice. She didn't need to. Joel and Cassandra left without speaking to me. Their lawyer gathered his papers quickly. In the hallway, through the courtroom door, I could hear Cassandra's voice, sharp, clipped, but I couldn't make out the words. I sat for a moment after they left. Mr. Okafor gathered his files. Roy, who had attended as a witness and stayed for the whole proceeding, came and sat in the chair beside me. Neither of us said anything for a while. Outside the courthouse, the April air was cold the way Guelph gets in spring. Not winter cold, but not warm yet either. That particular gray patience before things start growing again. I stood on the steps and looked at the street, the old downtown buildings, the light. Mr. Okafor shook my hand and said I should call him if anything further developed. I thanked him, and I meant it in a way I rarely mean things said in professional contexts. Roy offered to drive me home. I told him I was fine to drive, but that I'd take him up on dinner Sunday as usual. He nodded and went to his truck. I drove back to Elora alone, the way I'd driven most things in the last 9 years. The highway opened up west of Guelph, the land flattening into the flat gray-green of early Ontario spring. I turned off toward the property, down the county road, past the old Mennonite farm, through the last stretch of hardwoods that lines my northern edge. The farmhouse came into view around the bend, same as it always does. White clapboard, the cedar shake roof I replaced. 4 years ago, the old maple out front that my wife Diane planted as a sapling in 1987. She said she planted it because she wanted something that would outlast both of us, something that didn't need to be told what to do. I parked in the gravel and sat in the truck for a moment. Joel has not called since the court date. I don't know what happens between him and Cassandra. I don't know what he told himself about all of it, whether he's arrived at something like regret or whether he simply moved to a different strategy. That's not mine to carry anymore. The land is in trust. Patricia holds the documentation. Mr. Okafor's number is saved in my phone, and I hope I never need to use it again. Roy comes for dinner on Sundays. The maple in the front yard has been putting out leaves this past week. Small ones, still the pale green of early season, but there. My wife knew what she was doing when she planted it. She usually did. Some things you spend your whole life building. Some people spend their whole lives trying to take what isn't theirs, and sometimes, if you're patient enough and quiet enough and careful enough, you get to watch the gavel come down on exactly the right side. I walked inside, put the kettle on, and sat by the window in my chair. The land was still there. It was always going to be. I've been sitting with this for a while now. Long enough that the maple Diane planted has fully leafed out, and the mornings have that particular warmth that only comes in late May in Ontario. And I keep coming back to the same thought, not anger, not even satisfaction exactly, more like clarity. What Joel and Cassandra built was a house of assumptions. They assumed that age makes a person soft. They assumed that a man living alone on a rural property, someone who splits his own wood and drives himself to appointments, must be drifting. They assumed that the appearance of concern was the same thing as concern, and underneath all of that, they assumed they wouldn't be caught, because in their minds there was nothing to catch. They had simply decided the land was already theirs, and they were waiting for the paperwork to catch up. That's the thing about people who act without integrity. They don't see themselves as doing anything wrong. They reframe it. Joel genuinely may have believed on some level that he was protecting me. That's the most unsettling part. But belief in your own good intentions doesn't make the voicemail disappear. It doesn't change what he said to my neighbor or what his lawyer wrote in that letter. The truth has a way of accumulating quietly, long before anyone decides to look at it. I've thought a lot about what actually saved me, and I don't think it was luck. I think it was the decision made on one specific afternoon in Patricia's office to think clearly instead of emotionally. I was hurt. I was angry in a way that doesn't have clean edges. The way you can only be angry at someone you love who has chosen to become someone you don't recognize. But I didn't let that be the thing that drove me. I sat across from my lawyer, I told her the facts, and I let Mr. Doe, Okafor, tell me what the facts required, that discipline, the willingness to set down what you feel long enough to think straight. That's what gave me a fighting chance. And then the harder part, staying quiet. Months of phone calls where I was pleasant, visits where I made coffee, Cassandra telling me I seemed more relaxed. That kind of patience isn't passive. It costs something. Every time I said I'm thinking about it while knowing exactly what I had already done, that took more out of me than the court date itself. But it was necessary. The moment I showed my hand, they would have moved differently. Patience isn't just a virtue people stitch onto pillows. In situations like this, it's strategy. What I want people to take from this, if they're in something similar, a parent, a sibling, an old friend slowly being maneuvered out of their own life, is that the ground doesn't have to shift under you just because someone is pushing. You are allowed to know your own mind. You are allowed to act on it, quietly and thoroughly, without announcing yourself. Doing what's right isn't always loud. Sometimes it's 43 pages of documentation filed in a Kitchener law office on a cold January afternoon. The land is still here. The maple is still growing. Roy comes for dinner on Sundays. Some things hold.